that's being said. So if you'll please try to keep it down as best as you can. Okay, Mr. Casciano, if I can please get you to state your full name and date of birth for the record.
Christopher J. Casciano, 7279.
Before me is Christopher Joseph Casciano. Date of birth is July 2nd, 1979. That is correct, sir?
Yes, ma'am.
Allow me to introduce myself. I am Judge Simmons. We're here for a simple bond court arraignment. Today's date is Wednesday, July 20th. The exact time is 3:07 p.m. Once again, we're here for a simple bond court arraignment. I'm not here to try you in any way on whether or not you're innocent or guilty. I'm just here to inform you of your charge, your bond amounts, and your rights. You do have the right to remain silent. You have a right to a trial by jury. You have a right to have an attorney present. If you cannot afford one may be appointed to you by our public defender's office. Mr. Casciano, because your charge is general sessions in nature, I will not be able to offer you that right to a public defender. What will happen, there will be someone that will come and pay you a visit and ask you if you would like to exercise that right. If you choose to do so at that time, please do so. However, if you are discharged from this facility for any reason whatsoever, you would have to go down to the main county courthouse downtown with $40 to our indigent defense office, and they will basically screen you on whether or not you qualify for a public defender. For the charge that's being presented to you today, for any reason it's dismissed, discharged, not prosecuted, or you're found not guilty, it can and it will be expunged from off of your record. Because you are being charged with the general sessions charge, you will have that right to what we call a preliminary hearing. This is what the preliminary hearing right form looks like. If you wish to exercise this right, what will happen is that you'll go before another judge, and the law enforcement officer that took the charge out against you will be there to present the evidence on the behalf of the state, and your attorney will be there to present your evidence. Once that judge has heard all of the evidence from both sides, he or she will determine whether or not your charge will go to another court proceeding or whether or not it is dismissed. So if you wish to exercise this right, Mr. Casciano, what you would do is fill out this information here. You can give it back to me. I'll be more than happy to extradite it on your behalf. If you choose not to give it back to me, you must mail it to the address provided within 10 days. If you don't do so within 10 days, you will lose that right. When or if you're released from this facility, you will have a court date and time that will demand your appearance. We're very serious about you being in court the day and time that you're to be there, to the point that we will provide you with the name of the court, the address of the court, and the telephone number of the court. Do understand, if you're not in court the day and time that is assigned to you, you will be tried in your absence and issued a bench warrant for your arrest. Because your charge is general sessions in nature, if you do not show up for court, you can be fined up to $5,000, incarcerated up to 5 years, and or both. Casciano, you are being charged with the charge of reckless homicide. Let the record show that the victim in this case, Mr. Gunnar Cole Adair, who is the deceased victim, have a family member of the victim that's here to speak on the behalf of the family, and her name is Ms. Logan Adair. Ms. Logan Adair, if I can get you to please take a stand. Once again, I want to offer my condolences to the family. Because you are the victim's sister, you have the right to speak today. You will not be censored in any way whatsoever. So please be free, whatever it is you want the court.
Thank you.
Once you're finished speaking, Mr. Adair, I'll come back to you, Mr. Casciano. You can respond to what Mr. Adair has stated. You do not have to respond to what she has stated. You as well, sir. You have free reign. You will not be censored. Whatever it is you want the court to know and to understand, or the family to know and to understand, have that opportunity to express that. You will only have one say, and once you're finished, I'll come back to you, Ms. Adair, and then I will come back to you. Can you hear anything?
Now, yeah.
What about now? Okay. So after I have finished speaking, Ms. Adair, you will have the last say, and then I will come back to you, Councilor McKinnon, and then you will have the last say, and the court will make its decision from there.
And Your Honor, if I may.
Not right now. Not right now. Ms. Adair, you have the floor.
My name is Logan Adair, and I'm Gunner's sister. I'm speaking on behalf of him and our entire family. We are truly devastated from what has happened. The pain we've endured for the past 65 days is unexplainable. Each new day being worse than the last as we relive this nightmare daily. We wake up in the morning remembering that Gunner will not be here today. We don't have the opportunity to spend any more time with him or make new memories as his life was taken from us. We were robbed of that. This has caused a great deal of distress to us. Our grandmother has suffered from a stroke one night after getting so worked up and upset about Gunner's passing. I've lost nearly 30 pounds since losing my brother because I can't eat or sleep. His fiancée is pregnant with our son and has also struggled with maintaining her weight. That has caused a delay in their son's growth over the past 2 months. We're all depressed and hurt more deeply than my words could ever explain. Gunner's 2-year-old daughter doesn't understand that her dad isn't coming home. She speaks of him every day and she misses him dearly. Gunner will never get the chance to lay eyes on his son and will miss his birth as well. He will never get to take his baby girl to a father-daughter dance. He will never get the chance to watch his fiancée walk down the aisle to him as they exchange their vows. We've done our own research and learned that Christopher has recently moved to South Carolina in October. And we also found that he has previous record of reckless driving, along with some other senseless offenses. The family asks that he is held here without bond until trial, as we'll feel safer with him here rather than a few minutes down the road, or to prevent him from fleeing back to his hometown. What he's done is irreplaceable. My brother's life can't be restored. Please consider doing no bail at this time for a small peace of mind for our family.
Thank you so very much. Councilor McKibben, if you would please stand and I'll give you the floor, because I believe you wanted to say something and you have that floor.
Yes, Your Honor. May it please the court. I know you had indicated to Mr. Casciano that he would have the opportunity to speak, and since we've not had the opportunity to speak as his counsel, I wanted to advise him to not speak and let me speak on his behalf at this hearing.
And what do you say?
Ma'am, I'll listen.
Thank you. Councilor, you have the floor, sir.
Thank you, Your Honor. And it's a sad time for us to be here. I will tell you my condolences to all of you. Whether a crime was committed or not, this is the death of a family member. I feel for you, and I'm here representing Mr. Casciano, but my condolences as well. Your Honor, we are here today to request reasonable bond for Mr. Casciano. As you know, the standard by which Your Honor must look at this, as it is a simple arraignment, as my client is innocent until proven guilty and has such constitutional rights. The standard is to evaluate whether or not my client is a flight risk and whether or not that he would be a threat to the community, with other certain factors which, of course, Your Honor is well known and have judged many, many times. First, I'd like to take the flight risk. Mr. Casciano is not a flight risk. Mr. Casciano's wife, who could not be here because she is tending to their 1-year-old child, they've been together for 20 years, they've been married for 16 years, and they have 6 children. They closed on the purchase of a house here in Greenville yesterday. Investigator Stokes on this matter and I spoke. We played a little bit of phone tag for a while. We spoke over a week ago, and he indicated very calmly, particularly because Mr. Casciano had some serious medical injuries in this accident as well, that whenever we felt it would be okay for him to come down and turn himself in, that was fine with him. There was absolutely no indication from the authorities that there was any concern that he would flee, and he didn't. I spoke with them last week, said, can we come down here Wednesday morning? That was this morning. I said, meet me down here at 9 o'clock. Well, unfortunately, court came up for me at 9 o'clock, and he and his wife came in exactly on time and turned himself in, and he is here before you today. So those ties to the community, the fact that he turned himself in, the clear lack of concern of flight from the investigator and the police in this situation, even though they knew they were going to issue a warrant well over a week ago, I believe is very compelling for that reason. Not only that, Your Honor, Mr. Casciano is a truck driver. He has a CDL. He has a clean commercial driver's license. He works for Republic Services here in town, and he basically runs local routes. He is the sole breadwinner for his six children and his wife, and as I said, they closed on a house yesterday. Let me now address the threat to the community. I know Your Honor has read the warrant. I only received the warrant as he turned himself in this morning, today, by fax from the Law Enforcement Center. It states what it states, and I understand this is not a trial of fact, but the reason that this is so important to consider, Your Honor, is with regard to a threat to the community is the unbelievably unique circumstances of this, because in this situation, Mr. Casciano, while home, was notified by a neighbor with video that a man, Gunner Adair, was in an active stealing of his brand new Harley-Davidson motorcycle out of his driveway, which is the motorcycle he was driving at the time of the accident.
Which he intentionally.
No, ma'am.
I can't walk out.
Yes, you can.
Thank you.
Your Honor, there's no doubt about the accident. There's no doubt about the deceased, and that's a terrible thing. But we are looking at the threat to the community. Mr. Casciano followed him. To keep him in his sight, there is going to be records of 911 calls where he was calling the police to take up that pursuit. This was a brand new, very, very expensive motorcycle that the man stole directly out of his driveway. Nothing like this has ever occurred with my client before. He and his son were in the car. My client suffered a broken back. Not to mention, though there is suggestion that there was intent to cause this, which is not the charge, it's reckless homicide is the charge. One must consider why my client would intentionally run over his brand new motorcycle. That being stated, Your Honor, again, with the unique circumstances, given the fact he is the sole supporter of 7 individuals aged 1 to 22, his wife, he has just bought a house, he lives here, he has no flight risk, and this is a completely unique circumstance, Your Honor. We would ask for bond today. Thank you.
Is there anything you would like to say in response to what Councilor McKibben?
I can't hear you again.
Is there anything else that you would like to say in response to Councilor McKibben?
Yes, ma'am.
Okay.
If it wasn't intentional, I know you're not here to try him, but he wouldn't have reached up to 127 miles per hour chasing my brother. He was not on a Harley. It was a crotch rocket, secondly. As far as being the breadwinner and sole provider, I have my brother's fiance who's having a baby in 2 weeks. He was their sole provider. Now she's had to move in with her mom, and all of us are having to pitch in and help take care of her, her daughter, and almost son who's going to be here. I don't think that's a valid for him to be able to get out and take care of his family, and Gunner is not able to be here to take care of his.
Thank you so very much, Ms. Adair. Counselor, if you'll give me one moment. Counselor, is there something else you would like to say? And then I'm going to go forward with my decision.
The only other thing, since it was brought up in response, was there are material facts in dispute in the affidavit, including the speed. And other than that, why I raised my hand was we couldn't hear. I didn't know if you were on. You may have been on mute for that when you were speaking to the clerk. Thank you, Your Honor.
Thank you so very much. Once again, I want to offer my condolences to the family. Councilor McKibben, I am going to honor your request to have a bond set. For the simple fact is because this is a bondable offense, and this court, according to state statute, would have to set a bond, and I'm going to do my duty in setting the bond. However, it's going to be a significant bond, Counselor. So with that being said, Mr. Casciano, you are going to have a cash and surety bond set at $100,000. You have three options of posting that bond. The first option is to cash to this court in the amount of $100,000. Second option is to get a bail bondsman. He or she will charge you anywhere between 10 to 15% of that $100,000. Third option, not yourself, family member or a friend owning land or a home valued at $100,000 here in Greenville County, South Carolina.
6 kids.
You will have a condition of bond, and that condition of bond is that you're not allowed to have any contact with the victim's family. What that means, starting right now as I'm talking to you and you're looking at me, that means you cannot talk to any of the family members, call them, text them, send any type of voice messages, mail correspondence, no emails, no social media messaging on any platform about the victim's family to them or concerning them, and no third-party messaging. No contact means no contact, directly or indirectly. Do you understand that?
Yes, can I add one thing?
I'm sorry?
Can I add one thing?
Can you add one thing?
Yeah.
What I would basically advise you to do is to pick up that telephone over there and talk to your counselor and see if that one thing you want to add is sufficient enough.
I won't ask it. I'm sorry for bothering you.
You sure? No, you're not bothering me. It's just that your counselor has asked that you refrain from speaking.
Okay.
So if you want to talk to your counselor, and he can advise you whether or not, if it's okay for you to say that. Counselor, there's a telephone over there. If you would pick up that line.
Yes, sir.
Does she know about all the things they're doing to our family?
No, ma'am, I don't wish to speak.
Okay, thank you so very much. Okay, right now, we're going to have you fill out everything that I've spoken to you about in documentation form. So everything that was discussed in this bond arraignment will be in this paperwork. Once I hand it over for you to initial and sign, Would you like to relinquish your paperwork to your counsel?
Yes, ma'am.
Okay, thank you. Now, the preliminary hearing that I reviewed with you, did you understand what I explained?
Yes, ma'am.
Okay, he will basically advise you if he wants to go further with that. Any questions for me?
No, ma'am.
Okay. Go ahead and please take a step to the left. Counselor, if you would like to wait in the lobby, we'll get that paperwork to you as soon as he's finished with it.
Thank you, Your Honor.
You're welcome, sir. Family, once again, I offer my condolences. His bond arraignment has been completed. You are free to leave.
Thank you.